I'd like to turn to an expert on the subject, though. Brett Tolman is here. He's a former U.S. attorney and an executive director of Right on Crime. Brett, great to have you on the phone with us. Thank you so much.
Thank you for having me.
I've been following some of your commentary, and you say that the prosecutors have made a mistake by spending so much time with Michael Cohen on the stand. Why?
Yeah, the courtroom, strategy really does seem, it seems born more out of trying to do too much with a witness. When your case is weak, this is what you see frequently. You'll see, instead of precision, you see scattered, shotgun approach to try to bring in enough, evidence or enough commentary by a particular witness that you hope that it's sufficient to, convince the jury. But from what I see you're putting on the stand a convicted perjurer, an individual who is going to be destroyed on cross-examination by their own antics and behavior, much less the defendant in this case. And then they leave him on for 2 solid days and on subjects that for the most part are very irrelevant to what their burden of proof was. So it's a very dangerous game to play when you do that as a prosecutor, but it does show signs that they don't have a ton of confidence in their case.
Also, Michael Cohen further revealed himself to be even more duplicitous yesterday when they introduced evidence that there was a recording that he made without President Trump's knowledge of a conversation that they had about a different woman, not Stormy Daniels, but Karen McDougal. And it was presented yesterday as evidence that, oh, this is common practice. Look at them engaging in some sort of hush money or catch and kill scheme. But the message I'm getting from this is, hold up, this guy was supposed to be Trump's attorney, and he was secretly recording and then disseminating the audio?
Yeah, it's pretty outrageous. It is unethical behavior. It may have been illegal behavior, depending on where the recording was conducted. But take a look at this issue that not a lot of people are talking about in regards to that recording. Attorney-client privilege is very broad, and it's the privilege is owned by Trump in this instance. Michael Cohen, the lawyer, he cannot waive that privilege. So it's very, very shocking that the judge would allow this to come in to evidence. I've been shocked at what evidence has been allowed, each day that this trial goes on.
Yes.
But that in particular is very, very unusual to see conversations between a lawyer and his client.
Well, that seems like almost entirely what Michael Cohen's been talking about throughout this. He has had, he has revealed some of the conversations he had on Trump's behalf, according to him, with other people. But a lot of this was conversations he had with Trump personally. And to me, that seems like that's textbook attorney-client privilege that Trump is entitled to unless there's some other court proceeding that says, no, he's not entitled to it because there's a clear crime committed here or something, right?
That's right. You have the crime fraud exception, and you do not have the ability to waive that if you're Cohen. The prosecution should have been incredibly careful, should have established what we call a taint team that would be assembled to make sure that evidence they're going to present does not violate the privilege, because now you risk your whole case on appeal.
Well, could this form the basis of a mistrial?
It could. More to the point, if you had a judge that's perhaps maybe 98% of all the judges out there in the country on this case, I don't think this would even get to a jury. I think the judge would issue a directed verdict and would pull the case away from the jury and dismiss the case.
On this issue of attorney-client privilege, I can't help but notice that a lot more time was spent on that subject in Georgia between Fani Willis and Nathan Wade and his buddy, and everyone's very concerned about attorney-client privilege down there. But when it comes to President Trump, no concern whatsoever.
Yeah, no, it's like the rules of evidence. The judge also ignored a rule of evidence called Rule 403, and Rule 403 is to prevent any evidence that is confusing, irrelevant, or prejudicial to the defendant unfairly prejudicial. I mean, all of Stormy Daniels' testimony fell under Rule 403 and would have been eliminated. But hey, with Trump, let's throw all the rules out and let's just see if we can, get anything to stick.
Insofar as we're treating this as a legitimate case before a court of law, it is interesting to me that Cohen testifies yesterday extensively about how he was, taking initiative and handling payments and trying to fix things and advising Trump to pay this and telling him to do that. And from where I'm sitting, it sounds like Cohen is admitting he's the one who was responsible with coming up with all of these schemes and then advising his client in a legal capacity to follow his advice. So why isn't Cohen sitting at the defendant table rather than on the witness stand?
Yeah, you hit on a point that I wish more would talk about, and that is you can't have it both ways. You cannot be the arrogant, brash, egotistical fixer that he self-describes himself as, and then at the same time have people believe that Trump is the one out there doing everything and that you're not the one that's telling Trump what to do. Look, I've met these kinds of lawyers and I've dealt with them, and they don't listen to their client. They tell the client what they're going to do. And that's exactly what the evidence seems to suggest as well.
Yeah, it is really remarkable. Today, we also get the additional news that an appeals court, an intermediate appeals court, denied President Trump's request to lift or modify the gag order. They just said, nope, we're not going to change it. In fact, they said that Judge Merchan had properly determined that President Trump's public statements, quote, posed a significant threat to the integrity of the testimony of witnesses and potential witnesses. Brett Tolman, in your legal career, have you ever seen a gag order of this nature?
No, this is one of the more puzzling things. It's clearly within the First Amendment to be able to talk about witnesses, to be able to talk about your case. It's unconstitutional to issue a gag order, but not many people understand that the gag order is created. It's a mechanism in the rule of law that is created to protect the defendant, to ensure a fair trial. I've never seen it applied just to the defendant. And if it does apply, it applies to everybody in the case so that you can ensure fairness and you're not singling out one side or the other. Here we have Cohen and Daniels and anybody else on the prosecution side that wants to say whatever they want to say. And Trump is the only one that's gagged. It's unconstitutional. I expect that eventually, as they continue to work their way up the appellate process, some sanity will come to a decision on it.
Among the people President Trump and his surrogates, the people who work for him, are not allowed to talk about is former Justice Department official called Matthew Colangelo, who was number 3 at the Justice Department and is now working for Alvin Bragg on this case. In your experience as a federal prosecutor, have you ever seen an attorney go this direction in his career willingly? Matthew Colangelo leaving number 3 at the Justice Department to become a line prosecutor for the Manhattan DA?
No, I mean, it's never happened in the history of the country unless they were run out in shame and then later in life restored themselves and got into a district attorney's office or something of that nature. But to leave the number 3 position, and not only that, but to go then to a case like this, you have to have some serious judgment issues and absolute hatred for your target, Donald Trump, in order to make that kind of a career move.
When you say a case like this, you mean a case that's this poorly established, that's as weak as this one is?
Yeah, you're talking, it's a misdemeanor case that's been manipulated to look like a felony based on the potential of an underlying federal crime that was already declined to be prosecuted by the DOJ. I mean, if you wanted to pick the worst possible case you could ever, bounce out of the Department of Justice to, this would be it. So I tip my hat to him. His judgment, however, is lacking, and it's dangerous because it shows you that they're willing to do anything, and that the end is, justifies is every effort that they make, every rule that they break, that end, is justified.
Finally, and again, thank you for your time, Brett Tolman. In the court, Alvin Bragg is alleging that Trump is guilty of what would normally be considered a misdemeanor, but it's only a felony because he committed some other unspecified crime. Here's another situation where I wonder about your legal expertise. Have you ever seen a case where someone is accused of committing a crime, but they don't know what crime it is?
Well, and in fact, that's why we have the Fifth and Sixth Amendments. Our due process rights actually require the prosecution to clearly state the allegation that you are criminally investigating someone. And you have to be able to defend yourself against it. And in this instance, we still don't have anybody that's articulated what the theory of the prosecution is and what the underlying crime is. Everything we've heard is about a payment that Cohen made with very little evidence that even Donald Trump had anything to do with it, let alone making the entry into their books and business records. And what is it that is the felony that alleged bookkeeping crime was trying to facilitate? We don't know, because there's not an FEC violation based on a payment to keep somebody from telling a salacious story about a candidate. It happens all the time in this country.
Yeah, it's crazy. It's totally tyrannical. Brett Tolman, thank you, former U.S. attorney and now the executive director of Right on Crime. Sir, good to have you with us. Thank you for your assessment today.